Ruben Cantu, in the latter part of 2004, became one of 3 or 4 poster children, for lack of a better term, in the national Innocence debate. When I was confronted with the results of the NAACP Legal Defense Fund's investigation by a reporter from the Houston Chronicle who had done an incredible amount of work on the Cantu case, good work on the Cantu case. Lisa Olson is her name, and she's a respected investigative reporter. She told me what the Chronicle's conclusion was, and that was that Cantu was innocent. Asked me what comment, if any, I had, and I told her that I would have to look into the case because I didn't have an independent memory of the case at that time. I reviewed the file and was frankly shocked by what I saw. Shocked because when the Cantu case was in my office when I was DA and we were doing the Cantu case, I was young enough at that point to not understand that eyewitness testimony is not always reliable. I believed at that point in my life, naively, that eyewitnesses can be relied on. By 2005, when I was looking at the file, I had tried a lot more cases and had done a lot more reading, and the thing that I knew at that point was that eyewitness testimony is not something that can be relied on. Many states, in fact, have statutory provisions that require that eyewitness testimony be corroborated, that you can't prosecute, particularly in the capital murder context, a capital murder case on the basis of eyewitness testimony only, on the basis of a single eyewitness, which is what we had in this case. The Cantu case was troublesome because there was no physical evidence that connected him to the crime. There was no confession. He denied involvement until he died. The gun was never discovered, was never part of the file. And so the decision that I made in 1984, 1985, whenever it was that I made that decision, was to prosecute a very young person, even though he was notorious and well known to the police because of other incidents. I made the decision to prosecute him as a capital murder defendant on the basis of the testimony of a single eyewitness. And that shocked me when I saw it, because I couldn't believe that even at the age of 35, whatever I was, that I would have made that decision. And so I called Lisa back, and I said, I acknowledged that I had made a mistake, which I didn't realize at the time was unheard of for prosecutors to do. Prosecutors, I've subsequently learned, anytime they're confronted with the suggestion that they may have made a mistake, are more inclined to circle the wagons than to acknowledge error. But as I have told a lot of people since then, I was blessed with a father who hammered lots of lessons into me, one of which was, if you make a mistake, you pony up, and you do it as early as you can, and the reason why you do it, or the 2 reasons why you do it, are number 1, it's the right thing to do, and number 2, it's a smart thing to do. And I'd like to believe that the reason why I acknowledged mistake in the Cantu case was because it was the right thing to do, but I'm not sure that was the reason. There's no question that it was the smart thing to do. I have not been stoned to death by, angry prosecutors or. Anyway, That's the Cantu case. I don't know whether he was innocent. I have freely acknowledged that he may have been innocent. I have, although I've never acknowledged that he was innocent, because I'm bothered by the possibility that he was, and because I'm responsible for all of the decisions that were made in his case. I also, in the very same initial interview with the Houston Chronicle, accepted responsibility for his execution. And that created a great stir, around the country, and at least in circles that care about these things. And so I became, for the first time in my life, a rock star to the liberals, to death penalty liberals. And now I get to go around neat places making speeches and things like that. That's the Cantu.